Hi, I think we all would agree that the President of the United States should follow existing law when appointing an acting Attorney General to temporarily replace the departed Attorney General, Jeff Sessions, until a permanent Attorney General can be named and approved for the office. I think we can also agree that we should not be told that the President's action when following the law is unconstitutional. In the New York Times op-ed, two elite District of Columbia attorneys have immediately and incorrectly asserted that Mr. Whitaker's appointment by the President was unconstitutional and illegal. I'll quote from their op-ed. Mr. Trump's installation of Matthew Whitaker as acting Attorney General of the United States after forcing the resignation of Jeff Sessions is unconstitutional. It is illegal. Unfortunately for the people of the United States, this verbiage misrepresented the legality of Mr. Whitaker's appointment as the acting Attorney General. Let's take a look at why they have misinformed us. The Vacancies Reform Act of 1998 establishes requirements for temporarily authorizing an acting official to perform the functions and duties of certain vacant positions that require presidential appointment and Senate confirmation. Because permanent appointments to advice and consent positions, such as Attorney General, can require a lengthy approval process, Congress decided to allow the President to appoint acting appointees to temporarily fill a vacant position while a permanent nominee undergoes the rigors of an approval process by the U.S. Senate. The Act generally limits the period of time that such a position may be filled with an acting official to 210 days, beginning on the date the vacancy occurs, not when the official began serving in the acting capacity. Section 3345 of the Act allows three classes of government officials or employees to temporarily perform the functions and duties of a vacant advice and consent office under the Vacancies Act. First, as a default and automatic rule, once an office becomes vacant, the first assistant to the office becomes the acting officer. The President is not obligated to appoint a first assistant to the acting position, particularly if he does not have confidence in the first assistant. Alternatively, the President can appoint two other classes of people to serve as an acting officer of an agency instead of the first assistant. The President may direct a person currently serving in a different advice and consent position to serve as acting officer. Or, as in the case of Mr. Whitaker, the President can select a senior officer or employee of the same executive agency if that employee served in that agency for at least 90 days during the year preceding the vacancy and is paid at a rate equivalent to at least a GS-15 on the federal pay scale. Mr. Whitaker, as the Chief of Staff to former Attorney General Sessions, is a senior officer or employee of the Department of Justice. Mr. Whitaker served as Mr. Sessions' Chief of Staff from September 2017 to November 2018. That is more than the 90 days required by the statute. Mr. Whitaker's federal pay scale was at least a GS-15 rating. Mr. Whitaker's appointment to the acting Attorney General position satisfied the requirements of the Vacancies Act and is therefore legal. Anyone telling you that the appointment is unconstitutional and illegal is not telling you the truth. It is fascinating that two elite attorneys in the New York Times would be so anxious to misinform the public. Well, I hope this helps. Have a good day.